that you were to be here by 11:30. Had you not called, I would have revoked your bond and issued an arrest warrant for you. All right, so you have wasted the court's time. You have wasted the time of the staff here. We're all sitting here waiting on you to arrive. That's just totally unacceptable.
I apologize, sir.
Apologies accepted. Let's see. The court calls the case of the state of Georgia versus Vernon Morrell James. Who do we have present for the state?
Yeah, the Special Prosecutor Jackie Patterson for the state.
Good morning, Mr. Patterson.
Good morning, Judge.
And let the record reflect that we have Vernon James present on his own behalf. Mr. James, you have the right to remain silent. Anything you say can be used against you. You have the right to have an attorney present at these proceedings. It is my understanding that you've been before the court before. You did not qualify for the services of the public defender at that time. You were advised that you had the right to hire a private attorney. It appears that you have not done so. As such, you will be proceeding without the advice of an attorney pro se today. Is that right?
Yes, sir.
Okay. Mr. James, you've been charged in accusation 21 CR 002230A with simple battery, family violence, and terroristic threats. You were previously arraigned on these charges and entered a not guilty plea to them. Do you wish to maintain your not guilty plea?
Yes, sir.
And the previous time that you appeared before me, Mr. James, you requested a bench trial in this matter. At that time, you signed a formal waiver of your rights to a jury trial. As such, the bench trial was scheduled for today's date. The way this is going to work, Mr. James, is that the state has the burden of proof beyond a reasonable doubt in this case. As such, they'll call witnesses if they choose to, or present any evidence for the court to consider. If they call witnesses, you will have the right to cross-examine those witnesses, ask them questions. You also have the right to present evidence in your own behalf, but if you choose to, but you're not required to do so. You have the right to testify on your own behalf, but you do have the absolute right to remain silent. If you do testify, you should know that you're going to be subject to cross-examination by the state. Do you have any questions regarding how this case is going to proceed?
No, sir.
Okay. I'll call your first witness.
You know, if it pleases the court, since he's pro se, I think it's important that the court inform him of the dangers of proceeding without a lawyer. The Court of Appeals considers that that's very important, that he understands that he's not a lawyer and all those things that he has to cross-examine, direct, and all of that. I think it's important that we put that on the record, John.
Okay, I do believe that at the previous hearings that we've had in this matter that those things have been placed on the record, but I'm happy to do so again. Mr. James, we've given you a number of opportunities to hire counsel for yourself. If you do proceed pro se, that means that you will be subject to the rules of evidence in the case. You will not have the advice of a lawyer. And we have given you ample opportunity to hire a lawyer. You're going to have to go forward on your own if you do choose to proceed pro se. You understand what I'm saying?
I can't afford a lawyer right now.
Okay. And you do wish to proceed?
Do I have any other choices?
Okay, well, we have had an opportunity at a previous hearings for you to hear the offer in this case. If you want to speak with Mr. Patterson prior to this trial today, I'm happy to give you that opportunity for you to speak with him and for him to put whatever offer the state has on to give that to you to see if that's what you want to do.
Yeah, I can tell him that I'm offering him 12 months in the county jail. That's my offer in this case.
Okay.
Fine. You're offering 12 months in the county jail?
That's correct.
Okay.
If you're convicted.
I'm
In
convicted.
other words, that's the offer now. The judge will make the decision if you're convicted.
So what other choices do I have?
To go to trial or plead guilty and accept the 12 months in the county jail.
You can also plead guilty and go on, it can be a non-negotiated plea. If the state, I will hear whatever your background is. I'll hear the allegations against you in this matter. And if you want to go non-negotiated, then I'll make the decision as to what your sentence will be.
Okay. So I mean, it's saying I only have one choice, but to go to trial or take 12 months.
I can't make that decision.
That's my two choices.
Well, simply because the state is asking for 12 months does not mean that I will sentence you to 12 months. I would have to hear what your background is, and I would have to hear what the facts are in this case, and then I would make the decision.
Well, I mean,
I don't think that you have.
but I mean, I don't.
Listen to me. Listen to me.
Okay.
I don't think that you have been considering the seriousness of this matter.
Okay.
I tried to impress that upon you the last time you were here. That the charges that are against you, the seriousness of the nature of these charges.
Okay.
Even today, I don't believe that you have considered the seriousness of these charges.
Well, each time we went to court, it's always been rescheduling, and then asking for a lawyer. It never one time did it say what part happened on my behalf. Because all it was saying was,
Okay, hold on, Mr. James. Again, you have the right to remain silent. Anything you say can be used against you.
all right,
If you choose to go to trial, then I'm happy to hear whatever it is that you have to say
okay,
in regards to this matter,
Okay.
if you choose to testify.
okay.
We're ready, Judge.
All right.
Yeah, I call Officer McCain to the stand.
Please raise your right hand. Do you swear affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you state your name for the record?
Sergeant Richard McCain,
And Officer McCain, who are you employed by?
South Fulton Police Department,
And how long have you been so employed?
31 years.
And did you have the occasion on October 26th of 2019 to go to the residence of 2607 Brooksage Court in South Fulton, Georgia?
Yes, I did.
Is that in Fulton County?
That's correct.
And are you post-certified?
Yes, sir.
And how long have you been post-certified?
31 years.
And did you have the occasion to, when you arrived, to speak to a Lakeisha Phillips?
Yes, I did.
And tell us what you learned and what was the nature of that conversation.
When I first met with Miss Phillips, she told me that she had been struck and strangled during a domestic dispute with Mr. James, and that he had left the residence just prior to our arrival.
And when you say struck and strangled, can you go into a little bit more detail?
She told me that when he came home, she had been to a doctor the day before, or at some point in time, and had been contacted the day before and told that she was pregnant. Apparently, this may have angered Mr. James, and he wanted her to have an abortion, and began the physical altercation between the two.
And you indicated that he struck her and strangled her.
And that's correct.
And what happened after that particular part of the incident as it relates to a terroristic threats?
She went upstairs, gathered his clothes, threw them downstairs, and told him that she didn't want to be with him anymore and to leave. She then told me that he came upstairs, held her down, and then got up and appeared to have been looking, she said looking for a gun, but he never did find one. And that's when he exited the residence and left. And she called police.
Did she say that he made any statements about threatening someone while he was looking for a gun?
And that's correct. She said before he left, he threatened to kill everybody.
and then proceeded to look for a weapon,
Correct.
but did not find it.
Did not find one.
Okay. And was there any physical injuries to Ms. Phillips?
I did not see any visible injuries to her, such as any bruising or anything. But at times bruising doesn't appear till later. And I just told her then that if it become more visible to let us know.
And what was Ms. Phillips' state of mind throughout this incident?
She was upset.
Visibly upset.
Mhm.
That's all I have, Your Honor.
Okay. Now, Mr. James, this is your opportunity to ask the officer any questions, if you have any questions that you would like to ask of him.
Stand up. I don't have no question.
Officer, you may be seated. Your Honor, we call Lakeisha Phillips.
Please swear affirm the testimony here today will be the truth, whole truth, and nothing but the truth.
Yes.
Please state your name for the record and speak up. Please.
Lakeisha Phillip.
And Ms. Phillips, you understand that you are, you understand that you are under oath. I need you to speak.
Yes, sir.
Okay. Would you be more comfortable taking your mask off, or you want to leave that on?
Either way, I'm good.
Okay, why don't we take it off then if you don't mind? And Ms. Phillips, you understand that if you do not tell the truth today,
Yes.
that you have the possibility that I would charge you with perjury. You understand that?
Yes, sir.
Okay. And
Yes.
Ms. Phillips, you do know Mr. James, is that correct?
Yes, sir.
And how do you know him?
He is my boyfriend.
Okay. And if you will, can you identify him with an article of clothing that he has on right now?
He has on a green shirt that says "The Good Die Young," some blue jeans and green tennis shoes.
Yeah, let the record reflect that the defendant, Vernon Morrell James, has been identified.
The record so reflects.
And Ms. Phillips, at the time of this incident, were you staying at 2607 Brooksage Court?
Yes, sir. And I still live there.
And that's in South Fulton, Georgia, Fulton County.
Yes, sir.
Okay. And did you have the occasion to discover that you were pregnant shortly before this incident?
Sir.
And you informed Mr. James that you no longer wanted to be with him, is that correct?
No, sir.
Then tell the court, if you will, what caused him to strangle you and to hit you in the face?
I ain't never said he strangled me nor hit me in the face.
You
I was
understand?
upset. Yes, I was upset and I said a lot of things, but he did not do that.
So are you saying that you're lying when you, let me ask the question first. Remember I told you that you could be charged with perjury.
Yes, sir.
Are you telling us that when you told the officer that he strangled you and hit you, that you lied on Mr. James? Is that correct?
Yes, sir.
Are you all presently living together?
Yes, sir.
Still living together?
Yes, sir.
I assume you all had a conversation about this case prior to today. Am I correct?
I hadn't been knowing about it since day one.
Okay. So are you being threatened in any way today?
No, sir.
So you admit to me that you lied to the officer on Mr. James on this case,
I do it.
and you realize you're subject to being charged with perjury.
Right.
Okay. No further questions, Your Honor.
Okay. Mr. James, it's your opportunity to ask any questions if you would like to ask any questions of the witness.
I have no questions.
Thank you, ma'am.
State rest, Your Honor.
All right. Mr. James, now is your opportunity to present any evidence, any witnesses that you have if you choose to.
I have nothing, sir.
Okay. And I take it that means that you don't want to testify on your own behalf.
No.
Okay. All right. Let's see. Is there any closing statement?
Yes, Your Honor. Your Honor, it's clear in this case that the victim in this case, Ms. Phillips, is a reluctant witness. She told the officer on the incident of this day that he struck her and choked her. That's clearly undisputed. If you look at the testimony and the demeanor of the alleged victim, she indicated that she still lives with him. This case has been a couple of years. It is no doubt, Your Honor, that she's either fearful or she just do not want to see him convicted. But the true evidence in this case came from the officer in this case, Officer McCain, where he indicated that she was visibly upset. She indicated to him that she found out she was pregnant. He was upset. He wanted her to get an abortion. She refused to do so. He indicated that she threw his clothes down the stairs. And at that point, he choked her, he hit her, and then said, I'm going to kill everybody in the house. And then went looking for a weapon, but could not find one and fled the scene at that time. Your Honor, most lawyers believe that in order to convict someone of terroristic threats, that you have to have a corroborating witness. That is true, but it does not have to be an actual witness. It can be conduct from the defendant before, during, and after the incident. And in the case, Your Honor, of Snyder v. State, which is located at 312 Georgia Appeals 504, and Holly v. State, which is located at 298 Georgia at 52. And those cases stand for the fact that the corroborating part of this statute can be satisfied solely based upon the threatening conduct of the defendant prior to the actual threat. And in this case, he choked her, he hit her, and then said, I'm going to kill everybody in the house. So you do not need a third party that says, I heard the threat. It is solely can be corroborated under the case law that I just cited, under the defendant's conduct, his aggressive nature, and his actions prior to the threat. So therefore, Your Honor, the state has not only proved simple battery of family violence because he did live with her at the time, but the state has also proved the corroborating evidence that's required under the terroristic threat statute. It does not have to be an actual individual. It can be the defendant's conduct under the two cases that I cited prior to the actual threat. So we believe, Your Honor, that the state has proven this case beyond a reasonable doubt that he's guilty of both charges, and we also proved that it occurred in Fulton County.
Thank you. Yes, Mr. James.
Can I talk next?
Yes.
Well, what he's saying is probably true in both cases, but you got the history of our relationship. She actually developed lupus a while ago. And between the times, it's been rough times in and out with that medication. So her doctor was explaining to me, when she go through certain situations, y'all take a break and just leave because she has mood swings. I've been fighting. She hasn't worked for a couple of years. So I've been holding this whole family together. We had this happen in 2019. It may have been an argument, but I have no kids. I want everything in the world to have a kid. So that can't be true. She has a daughter, my stepdaughter, but I don't have no kids. We've been working on kids for the longest. We've been working on kids. So this can't be true right here. This can't be true. And I love her dearly. I love her dearly. And we're gonna get married together and everything. So this is nonsense. That's why I didn't at the time I was going to purchase a lawyer and our furnace went out. So I had to pay $5,000 to get the furnace. And then that kind of messed my money up. So I couldn't purchase the furnace at the time. And I have 12 employees. Between the pandemic, I'm down to 3 employees. So now things are getting real rough. Our daughter is in the hospital, in the mental hospital right now. And right now, we're struggling, trying to hold everything together right now. Trying to hold everything together. So all of this stuff that's being said is nonsense. I love her dearly. We are fighting. She's fighting with lupus. That's the reason why we're late. We got ready to leave, and then she started feeling bad. She had to lay down. I had to let her lay down. She wasn't feeling well. She was not feeling well. So I know it's my fault that I was late, but I was trying to bring everything together. We came here in the same vehicle. But this is the counselor and the doctor. They say when she goes through things she wants to do in her room, she has to sit down. She has to be by herself. I learned that through the stages of us being together. If you look at the ambulance report, that year the ambulance probably been in the house probably about 20 times.
I agree. You were given the opportunity to speak, to cross-examine.
No, that's my closing arguments right there. You have to know the case before you say that.
Hold on, Mr. James. Take a breath, okay? Just take a minute, okay? All right, I'm going to be in recess for a couple of minutes to give you an opportunity to relax and get yourself together, okay? Court will be in recess for a couple of minutes. Okay. Are you ready to proceed, Mr. James?
Mhm.
Yes.
Mhm.
We have a court reporter that's taking down, it's Madam Court Reporter on it, that's taking down everything that you say. So you have to answer me with a yes or no.
Okay.
Okay, so you ready to proceed?
Huh?
Yes?
Yes.
Okay. Um, So you can comment on anything that you heard as far as the evidence goes in the case, and I'm happy to hear what you want to say about that. So continue.
I would just say explaining that the allegations can't be true. I don't have any kids. We trying our best to have kids. And between the times of that was going on, we was going back and forth between the medications that she was trying to take. Medication that it was giving her for a lupus.
Once again,
it wasn't agreed.
I would have to object. This closing.
I'm explaining to her.
Can you hold on a minute?
Okay.
The closing is not related to what was testified to at trial.
I understand that, but I'm gonna allow you to continue. Go
Okay,
ahead.
so that kind of explains the up and down with the mood swings. You can check the records. Her medication was going up and down. So that made her doctor actually explain to me, hey, she go through things, she's gonna find her safe place, and she go through mood swings. So I'm trying my best to keep our family together. We have no physical, it was no physical damages, strangulation, hitting. I'm a big person. So if I would have hit her or strangled her, you would have seen the physical, the evidence on her. Strangulation, she's lupus. You know, when you touch it, if I touch her right now and do like that, it'll turn black. So you would have seen it. Her skin is different. So I didn't touch her. All I did was, okay, you're upset right now. Walk away, calm down, things get back together. And we struggle for that. And now everything is together now. Now we good. So my problem was, only problem we had was me not spending enough time. That's what our problem was. Me not spending enough time because I had to work double because she wasn't working at the time. She's not working. So I had to work double to take care of everything at the house. So the argument was about me not spending time. That's what the argument is about. Not about me not wanting to be with her about having no kids. I don't have any kids. I'm praying like forever to have a kid. So what he's saying may result to another couple, but this is not us. We are a loving couple.
Okay. All right. Thank you, Mr. James. I appreciate it.
And lastly, Judge, in closing, is that this defendant should have thought about this way in advance of today. Your Honor, the only issue at hand here is whether the state has proved this case beyond a reasonable doubt, and we certainly assert that that's been done on both charges.
Thank you.
Can I say one more thing?
Yes, sir.
I also want to say that I'm a pillow to the community. I have an electric company and I supply work for the guys that's unfortunate, the ones that's not doing so good. I'm showing them a better trade and I keep everything straight. So I'm actually a pillow to the community. How do you explain that? Have about had 10, but I'm down to like 5 employees right now.
Let me just say, Mr. James, you know, people can be late, and if people in my courtroom know that I'm not, you know, that when people come in, especially with Zoom these days, I'm very accommodating to that. And that's not something that normally gets my dander up, okay? But what I would expect when you come in 30 minutes late and we're waiting on you, if it were me, the first thing I would say is, I am so sorry. You know, I would apologize. And I know that this is an intimidating situation, being in court if you're not, you know, if you don't do this all the time. But if you immediately apologized and you had immediately said to me that I had a medical issue, as you said, you know, that goes a long way. A simple apology to make people feel like they're just, that you don't think that my time and our time is not as important as your time.
I'm sorry,
I understand. That's why I said I understand that this is an intimidating situation. Okay. I also believe that I've seen you a number of times now, and we've discussed this case. We've given you the opportunities in the case, but just know in the future that if you know that you're in the wrong, explain to people, and more likely than not, they will understand,
Right.
as I now do. But do that on the front end as opposed to the back end, okay?
Mhm.
Based on the evidence in this case, I'm going to find that you are guilty of the charges asserted against you. We're fine for right now. We're fine for right now. Simple battery, family violence, and terroristic threat. Listen to me now, okay? Just listen to me. All right. So now that I found you guilty of these charges, I have asked to, and I'll hear from the state regarding this. I've asked the pretrial run your history. So if what you were telling me is true, I'll see it on your history, okay? And I will take that into consideration in pronouncing sentence, all right? Okay, so Mr. Patterson.
Yes, Your Honor. Domestic violence in this country and in Georgia is just simply out of control, Your Honor. His actions were totally unacceptable. Next time he could have been facing aggravated assault, and after that, he could be facing a murder charge. We believe, Your Honor, that under the severity of what this man's actions did, he deserves some jail time. We ask, Your Honor, that the court sentence this man to 12 months in the county jail on the simple battery family violence, and we ask him to sentence him to 12 months concurrent on the terroristic threats, which is a total of 12 months in the county jail. We ask the court to sentence him to a $2,000 fine, $1,000 on the battery, $1,000 on the terroristic threat. We ask that he be sentenced to a family violence intervention program. We ask that instead of no violent contact with the victim, we believe, Your Honor, that he's going to kill this woman the next time. So we believe that he should have no contact whatsoever with this victim. And Your Honor, that is the recommendation of the state. His criminal history includes a first offender's 2001 drug case and a 2002 DUI drug case as well, with a probation violation and a parole violation.
Okay. Do you know, Mr. Patterson, did he spend any time in jail prior to?
No, I'm not familiar with that. I think if pretrial is here, or I think they may be able to answer that question, or one of my colleagues, Orca Story, she did run his record. Ms. Story, are you still online? We can't hear you, Ms. Story. Unmute. You can't hear you.
You're on mute, Marshall Story.
This is with him. Thank you.
Good morning, Your Honor. Mr. Patterson, if you would give me the spelling of the defendant's name and his date of birth, I'll look it up in the jail screen.
Sure, it's Vernon Morrell James, James.
Date of birth, please, sir.
I don't have that with me, but Ms. Story is now online.
I'll look into it. Thank you.
Ms. Story, can you hear us?
Yes, his date of birth is January 19th, 1978.
And do you have his history with you?
I do.
Can you please inform the judge of that, please?
Your Honor, the defendant has 5 cycles. The first arrest is cycle 1, and that was on November of 2000. It does appear that the charge was a violation of the Georgia Controlled Substance Act, but it looks as though one of the charges may have been first offender. And he was convicted again of that felony charge, but it looks as though he received first offender on that particular case. And then it goes into sentencing. He was confined to 2 years, probation, 12 months with community service. And then on the second charge, the violation of the Controlled Substance Act, it looks as though that was confinement of 2 years. Let's see, cycle 2. It almost looks as though these cases may have been combined at one point because it's also a 2001 arrest. And that is where there is a charge of DUI, driving under the influence, and a second charge of the violation of the Georgia Controlled Substance Act. Under that disposition, he was found guilty of the DUI charge. He was also found guilty of the violation of the Georgia Controlled Substance Act. And there's a third charge of obstruction of law enforcement officer. He was also found guilty on that matter, and a driving while license suspended or revoked. He was found guilty on that as well, and received a sentence of time to be served concurrent, 12 months on the violation of the Controlled Substance Act, 2 years confinement. And that's why I believe that these cases may have been merged in terms of the sentencing, because it is that same sentencing with an additional recommendation of a $1,000 fine. Regarding cycle 3, there is a violation of probation, and that was August of 2001. And he was found guilty on the violation of probation. And it does say here on cycle 3, there's a sentence date. And it says that the charge is a probation violation, sentence confinement 2 years, a charge of to be served concurrent with the confinement of 2 years. And there was I did see a parole violation earlier. I am looking for that. Yes, under cycle 4, which says May the 2nd of 2003, there is a parole violation.
Your Honor, respectfully, may I ask you, Ms. Marshall-Stewart, were you finished? I did not want to interrupt, Your Honor.
Oh, no, yes.
Okay.
Cycle 5 then is this current case, Ms. McCutcheon.
And is the current offense date May 6, 2021?
Yes.
Okay, Your Honor, according to the Odyssey jail screen, the defendant was booked into the Fulton County Jail on May the 6th of 2021, and he was confined for 2 days, booked out on May the 7th, but the jail shows 2 days confinement.
All right. And can you tell me prior to today, at the previous Orca hearing, what was the offer that was made to Mr. James?
Your Honor, the previous offer was on a plea to the the simple assault, battery, family violence charge. That plea offer was 12 months probation, and the domestic violence intervention program, along with 40 hours of community service and a $500 fine.
And it's my understanding from what I've heard from both Ms. Marshall-Stewart and Ms. McCutcheon, Mr. Patterson, that there's no, aside from these allegations or these charges of simple battery, family violence, and terroristic threats, that he doesn't have any other violence in his history. Is that correct?
That's correct.
That is correct, Your Honor. They appear to be mainly drug charges.
And he has not had any other charges since the early 2000s.
That's correct, Your Honor. I can request that an updated history be run as of today, but I believe the last history is within the past year.
Okay. And we have asked that pretrial run that for us. Anything further, Mr. Patterson?
No, Judge.
Anything further, Mr. James?
What to say?
Can you stand for me? Taking into account the testimony that I heard, taking into account that this is really your first charge of any type of violence, and that your history is from the early 2000s, I'm going to sentence you to the simple battery family violence to 12 months to serve 2 days, credit for time served 2 days, the balance probated, a family violence intervention program, 200 hours of community service, and $1,000 fine. As far as the terroristic threats, the sentence will be 12 months to serve 2 days, credit for time served 2 days, balance probated. You're already going to have the family violence intervention program, 200 more hours of community service, and $1,000 fine. Okay, that's going to run consecutive. So you're going to be on probation for 2 years. And it's going to be, I'm going to require that you be on probation for the entire 2 years. All right. So while you're on probation, I know that you're running a business, that you're taking care of your family, that I'm going to waive the probation fees for you while you're on probation, but you're going to have to report and be on the probation for 2 years. Okay. All right.
And Your Honor, did the court mention no violent contact with the victim? Of
course, and no violent contact with Miss Phillip. Okay.
Thank you, sir.
Do you have any questions for me?
Sure.
Okay. So you'll be put in touch with probation as far as when you'll report, and I don't expect that you're gonna. I expect that you're gonna. That you are going to report to probation as you're supposed to. That you're not going to have any violations of probation, and I hope you consider the words that I said earlier about, if you run into trouble, if something happens, just let someone know. If something happens with probation, just don't not show up. Call them, let them know, stay in touch. If you stay in touch, people will be, they will be more mindful than if you just go missing.
But we did call and we talked to the lady and she said, take your time.
Well, nobody says, I was sitting here listening. No one said take your time. Because
the Fulton County lady that called us this morning.
Okay, well, you're fine that you're here. So we appreciate that you called, but all right, you have any questions for me?
I'm sorry.
All right, good luck to you, sir.
Your Honor, that's all of my business with this court. May I be excused?
Yes, have a good day. It's always good to see you.
Thank you.
All right, that concludes the calendar for today. I'll see you all next time. Thank you,
Thank you, Judge.
You coming in at the last minute for us. Thank you.
Good day, Judge. Thank you.
You're awesome, Ms. McCutcheon. Always good to see you.
All right, thank you, Judge. Good to see you as well. Bye-bye.
Judge, do you have a 1:30 calendar?
1:30.
That's been resolved.
Oh, okay.
So, okay, thank you.
Okay.
All right.
So that
Y'all have a good
concludes the
day.
business for today, correct, Judge?
It does.
All right. Thank you. Good day.